Back into the building.
Check 947-7677. If you are long distance within the state of Maine, I also have a toll-free number. It's 1-877-331-9400. And it will.
All right, it is 3 o'clock, so we'll go ahead and get started. Couple of quick things before we dive in though. I see that people are coming in from the waiting room. If you could please ensure that you are muted, that will help cut down on any feedback or extraneous noise today. So I appreciate that very much. My name is April Perkins, and I am the Director of English for Speakers of Other Languages, Bilingual Programs, and Title III here at the Maine Department of Education. And I am thrilled to be joined by Sarah Forster. Sarah, would you like to introduce yourself?
Hi, I am Sarah Forster. I'm an Assistant Attorney General in the AG's office here in Augusta. Okay, actually I'm home in Brunswick, but don't tell anyone. And my primary client for many, many years now has been the Department of Education.
Thank you so much for joining us today, Sarah. We also do have Robin Fleck with us, who will be moderating the chat room. So thank you very much, Robin, for helping with today's presentation. All right, with no further ado.
Webinar.
Oops.
While you're walking.
Everyone could make sure they're muted. That would be very helpful. Thank you so much. All right. So just a couple of housekeeping things for everyone. This webinar is being recorded, of course, because there are some people who couldn't attend today. So we want to make sure that this is archived for them. So because it's being recorded, we do ask that you please protect student confidentiality. So if you are asking questions in the chat, we ask that if you're referencing specific students, please make sure that you don't use any personally identifiable information such as names, countries of origins, districts where students attend, etc. That is very much appreciated. And because we do have quite a large number of people joining us for this presentation today, we are going to direct questions to the chat. So please do feel free as the presentation proceeds to write your questions in the chat. And there are a few pauses built into the presentation where we will stop and Robin will read a handful of those questions for us out loud, and Sarah and I will respond. If we don't have the opportunity to answer all of the questions that you have today, we will be sure to note them all and provide responses in writing, and I'll share all of those responses by email to everyone who has registered for today's presentation. Okay. So the conversation we're having today, I think obviously by being here, this is something that is important to you, and it's certainly very important to me in my role at the DOE. But I want to make sure that we start this conversation keeping in mind that Maine has many students who are English learners who come from a huge variety of educational, personal, and linguistic backgrounds. And they bring with them many different experiences and wealth of knowledge. If you're interested in learning more about the students that we have here in the state of Maine, you did receive the presentation slides in the calendar event. And so that English Learner Data Dashboard is something you can click on, and it will take you to the Maine Department of Education website, where you can browse through some of the very interesting data points that we have on our students who are English learners, including languages spoken, where they are located across the state, percentage of enrollment in special education, all kinds of different data points. So I encourage you to take a look at that. I would also like us to keep in mind as we proceed through this presentation that for a district to have a student who is an English learner in their community is a wonderful thing, and we celebrate having them there as an opportunity for all members of the school community to learn and grow. So I'm personally very grateful that Maine is a state that has approximately 5,500 up to 6,000, depending on when we check the numbers, English learners. The final thing that I'd like to say to frame this conversation is I really just need to express my very sincere gratitude to all of the Esol educators that we have in the state of Maine. It is my honor and privilege to serve them in this role as director of Esol. And I can truly say that these ESOL educators are among the most dedicated and professional teachers that we have in our state. And I'd like to encourage you, if you are someone who in your district or your region of the state is responsible for making sure that the civil rights of students who are English learners are met, if you discover through this presentation that there are areas where your district or your region could improve, I'd like to encourage you to think about this as something that is a shared responsibility. So ESOL educators bring a lot to the table. They're wonderful advocates, they're wonderful sources of information, but they alone, of course, cannot make the lasting change that we would hope to see for our students who are English learners. So if you're thinking about long-term changes, to really consider the team of individuals that would need to be involved in making those changes happen. All right. So the Maine Department of Education, of course, serves as a partner to all Maine SAUs. We're here to provide you with information, support, and resources so that you can successfully meet the needs of all students, including, of course, students who are English learners. If you do find yourself with any civil rights concerns, the Maine Department of Education is not a civil rights enforcement office. And that's because, as I said, our role is a supportive role rather than an enforcement role. So if you have concerns that you feel you'd like to address, you're welcome to, of course, come to me, and I will thought partner with you, and I will provide you with information and resources. But if something escalates beyond that point, then the link that I've provided on this slide describes for you how you would pursue a concern around civil rights. Okay, so today's presentation is basically broken into 3 parts. We'll begin with a historical context, which sets the foundation for the rights that we'll discuss in the second part of the presentation. And then finally, we will talk about civil rights in the current context that we are all living in through the COVID-19 pandemic. So for the first portion of our presentation today, I will pass it over to Sarah.
Thank you. Thank you. I feel really lucky to have been asked to be included in this presentation because I think that all of you have a pretty awesome role within our public education system. You are literally part of a tradition of expanding public education to ensure that, in fact, all students are educated. And that all comes from Brown versus Board of Education. When I teach school law, and I don't know if any of you have had to suffer through my school law class, but if so, just, you know, be nice, be kind. The Brown Revolution, the notion that groups of students were entitled to an equal opportunity and an equal right to participate in American public education, was a complete and utter game changer. Because once the court had said that, with respect to students based on their race, what was to stop the courts from saying the same thing applies to a student based on their national origin, to a student based on their ability or disability, to their student based on whether or not they are in this country legally or illegally. In other words, it threw the doors of public education wide open, and you are some of the faces and the people and the heart behind making sure that that actually happens. Because no lawyer, no matter how good, can actually achieve making public education available to all. That's on you. And I'm really happy that April thought to include me in this presentation, because I like to think that I'm doing a little bit to help make sure that you all know what the law and the tools at your disposition are to make sure that you can do your job better. So who are these children that April, because I can't make a PowerPoint slide to save my life, has included? Well, hold that thought because we'll get to them soon. Next. So, before the civil rights movement, there were no explicit federal protections for students who were in the process of learning English. Segregation based on students' race, ethnicity, language was commonly practiced in schools, and in fact, it was perfectly acceptable to simply leave those students to the side And sometimes, to make matters even sort of worse, it would be because really, you know, their parents wanted them to do other things. English-only laws were prevalent in the United States, some of them still in existence many years later than you would have thought they would be. In fact, in Maine in 1919, we had a law that said no languages other than English in schools. Imagine how that must have felt for our neighbors to the north or to anyone else who found themselves in Maine and did not speak English, and not just speak English, remember, but speak English in a manner that you can be open and able to receive public education. Let's go. So, the Civil Rights Act of 1964 sort of started the ball rolling. A decade after Brown versus Board of Education, the Congress had gotten into this idea that it had to be more than simply the courts ordering these things. Courts have one very big disability. They don't control armies and they don't control funding. And so with no army and no wallet to use as persuasive measures, a decade after Brown, the courts were literally overrun by desegregation cases. Almost every major metropolitan area had one or two or more desegregation cases going in the court. Something else had to be done. So, Title VI of the Civil Rights Act. No person on the ground of race, color, or national origin should be excluded from participation in or denied the benefit of or be subjected to discrimination under any program or activity receiving federal financial assistance. So, any guess who receives a lot of federal financial assistance? Yeah, I'd throw it out there, public education. In 1967, the Bilingual Education Act was included in Title VII as part of the ESEA. Now the ESEA, which most of us think of today as ESSA, and before that as No Child Left Behind, was really starting out as the education plank in President Johnson's War on Poverty. The concept behind the ESEA from the beginning until today is that students that are in disfavored circumstances, primarily based on poverty, have a special educational need, and that frankly, that need requires more resources. And by resources, let's talk about it, it's money. So, as the education plank in the Great Society, the ESEA specifically set aside additional federal funds that would supplement the education of students who are disadvantaged, or in plain terms, poor. It expanded, obviously, since its beginning, to include migrant students, to include homeless students, to include Head Start and pre-K students. But the core issue that poverty causes both educational deprivation and requires additional supplemental funding remains the same. The Bilingual Education Act provided federal funding for competitive grants that would support innovative language programs for students who are language learners in low-income households. So there it is, the tie to ESEA. Bilingual instruction wasn't required by the Bilingual Education Act, but it allowed for innovative programming to be promoted and encouraged. The Office for Civil Rights, which is a federal entity, got into the game because they were finding plenty of civil rights violations in their Title VI compliance reviews. They decided that there needed to be some specific meat put on the bones of the statute and the regulations, and they were very specific. School districts needed to take affirmative steps to ensure that students learning English could access the instructional program. In other words, it wasn't enough to simply provide a parallel universe of English learner instruction. English learners shouldn't be assigned to special education classes based on their lack of English proficiency. Talk about cross-pollination in a very bad way. nor should they be denied access to college prep classes due to, again, a basic failure to assist them in learning English. The goal was to teach students English as quickly as possible, but at the same time, to retain that critical family involvement by communicating with families in a language that they can understand. Okay, so back to our kids in the original slide. In 1971, based on a desegregation order, San Francisco's public schools were desegregated. And it turns out, in the San Francisco Unified School District, there were approximately 2,800 students who came from families that spoke Chinese in the home and who would be classified as English learners. About 1,000 of those students attended schools in San Francisco that had a support program in place for them. The other 1,800, not a small number, were not as fortunate. They were assigned to schools that had essentially nothing in place to support their English learning needs. And so while they were welcomed in the door, that would be unlike the students in Brown 2 decades before, they were welcome in the door, but once they got in the door, it was frankly practically impossible for them to achieve and learn alongside their classmates. Interestingly, they brought this lawsuit, and unlike almost every other civil rights lawsuit of the time, they did not ask for a specific remedy. If you think about a parallel universe, at about this time, the first cases raising the rights of students with disabilities were being brought. And those lawyers had very, very specific designs on what the remedy should be. Have any of you heard of the term FAPE, or the least restrictive environment, or the procedural safeguards? Those terms, while everyone knows that they're embedded in the IDEA, didn't start there. They started in the settlement agreements reached in 2 cases involving challenges to states that deemed certain children with disabilities uneducable, and thus not part of their compulsory education laws. So in that case, the lawyers asked for very specific rights and remedies, and because they were settlement agreements, they got them blessed by the court, and next thing you know, there they were before Congress as the IDEA. So our Lau plaintiffs, in comparison, had a different approach. They wanted, A, the court to determine that it wasn't enough simply to say that they were being treated the same, as in let in the door. Oh, and here we have our bilingual cat, Oliver. Yes, Oliver is very, very interested in this subject, and he's also very, very interested in Zoom. So that's a little bit of a, well, it's a combination, let's just say. Okay. At any rate, these plaintiffs simply asked the court to order the San Francisco Unified School District to do something. And the court said, we're not educators, but we can imagine that teaching English to these students of Chinese ancestry might be one possible resolution, or giving instruction to the group in Chinese might be another possible outcome. The point was, the court ordered the district has to use its considerable educational resources and knowledge to figure out a way to make their participation in public education truly equal by being equitable and ensuring that their language needs were met. The Lau remedies are actually a very interesting set of requirements because, again, this was something that Congress did after Lau. And so while Lau said, please, San Francisco Unified, do something about this, show us that you get it and do something about it, as you'll see, as we roll forward, they've become quite specific about what the options are. The Equal Educational Opportunities Act was very clear. It codified the conclusion in Lau and was very explicit. You cannot deny educational opportunities to an individual on the account of her race, sex, color, or national origin by the failure of an educational agency to take appropriate action to overcome language barriers that impede equal participation by its students in instructional programs. So, of course, that was only the beginning, and there were many questions that remained. One was, how were we going to judge whether or not any of the steps that the schools took after Lau were actually sufficient? So in Castañeda, 1981, and this is a case from a circuit court of appeals. In other words, it's a step below the Supreme Court, which many lawyers will tell you is where most of the action actually happens, because as you may remember from civics class, the Supreme Court gets to pick its cases, and they don't pick that many every year. In Castañeda, they had to come up with an analysis of whether or not what the Raymondville Independent School District was doing was good enough. It certainly wasn't a situation like the Lau plaintiffs a decade before, where they were receiving no services, but the question was, were they receiving enough? Castañeda gave us a three-pronged test, and trust me when I say this, lawyers love tests, because it gives us the questions to ask you, our clients. And the Castañeda test said, if we need to figure out whether or not an educational program for students who are English learners is effective, we're going to look at, first, is it based on sound educational theory? Now, many of you who might be refugees from scientifically based instruction, remember that debate? There's a little bit of the same concept here. Every profession, as you know, feeds on its own. And so, sound educational theory means an educational theory that has been adopted by some significant mainstream group or groups as being a high quality approach to education. Second, is it implemented effectively with sufficient resources or personnel? It's all fine and good to have a good program, but if you don't have a single teacher that's properly trained to administer it, how exactly is that going to go? And then finally, is it proven to be actually meeting your students' needs? In other words, courts are always willing, well, not always, but most of the time, willing to defer to the expertise of educators, since they are not educators. But at some point, if what the educator is seeing is that it's not working, you have to try something else. Plyler versus Doe. But for the Supreme Court confirmation hearings of last week, I would have thought that Plyler versus Doe might be the most endangered Supreme Court decision. Imagine the alternate universe of Plyler versus Doe. Here you have Texas, a frequent participant in educational rights suits, and this is a class action brought on behalf of students of Mexican descent. The Texas legislature passed a law that essentially said any school district could deny enrollment to students who were not legally admitted into the United States. Now, because the local districts could deny enrollment, that essentially also meant that the state didn't have to provide its share of funding. And so what do we do? Well, the Supreme Court, as some of you may remember from either your high school or college experiences with civics, has essentially two tests that they use when they're trying to decide whether or not people are suffering from a loss of equal protection of the law. One test is called strict scrutiny, and that's what's given to statutes that, all statutes, or almost all of them, distinguish between two groups of people. The question is whether or not that distinction is appropriate or inappropriate. For some groups of people and situations, we use what's called strict or heightened scrutiny. Questions of race, questions of nationality, questions of religion, Those all normally trigger strict scrutiny. Other things that trigger strict scrutiny are cases that involve fundamental rights. But what the Supreme Court knew in 1981 is that a prior Supreme Court decision had said that education was itself not a fundamental right. So even though these students were students of Mexican origin, the case was not brought as a race discrimination case. And as a result, the court had neither what's called a suspect class nor a fundamental question. Is it a fundamental right? Is it in the Constitution? No. So they were left with essentially what's called the rational basis test. And those of us who are lawyers that defend states love the rational basis test. The rational basis test says, tell me a story. Tell me some explanation why the legislature in your state would decide this. Well, guess what? This is one of the few cases in American legal history where the Supreme Court essentially said this Texas statute fails the rational basis test. The court said it was irrational to, simply because they were here in the country illegally, not provide education to these children. And their reasoning couldn't be more simple. Education, or the lack thereof, would condemn these children to a permanent second class or lower class status that was completely contrary to our American system of public education. In addition, there was no evidence that these children were going to go back to where they came from, predominantly Mexico. They were going to stay and work and be a part of our society. And what interest does the state of Texas have in creating an underclass that would be not able to perform at their best as citizens, as participants in a community, as workers? So anyway, the Supreme Court determined that both children who are in the country illegally are covered under the Equal Protection Clause, even though they are not citizens, and that these students had a right under the Equal Protection Clause to a public education. You might imagine, thinking about the last few years and our country's feelings about people who come over the border, that this might not be a majority opinion these days. We'll have to see. But as we sit here today, the reason that all of your administrative offices are very careful about asking for immigration documentation as part of enrolling in school is because Plyler versus Doe says you cannot discriminate based on whether or not an individual is in this country legally or not. One little unfortunate footnote to this case: by the time a case gets to the Supreme Court, the record has been cleaned up, the arguments have been all polished. Well, for people who go back below to the very district court where this case started, it turned out that in fact, the good people of Texas had been a little, what's the word? Let's just say they didn't quite get it right. Some of the children who were these plaintiffs were actually born in the United States, albeit to parents who had come here illegally. Do you know what those children born in the United States to those parents who had come here illegally were and are? The word is citizen. So oddly and sadly enough, in their attempt to deal with this statute, they actually tried to deny the benefits of a public education to students who were in fact exactly the same citizenship-wise as the other children. Anyway, I believe that's the end of, oh, no, one more. As if federal law isn't enough, Maine itself gets into the act when it comes to discrimination in education. It's going to discriminate against cats in about 2 minutes. The Maine Human Rights Act The opportunity for an individual at an educational institution to participate in all educational, counseling, and vocational guidance programs, apprenticeship and on-the-job training programs without discrimination because of sex, sexual orientation, a physical or mental disability, national origin, or race is recognized and declared to be a civil right. And just in case the dots aren't tightly enough connected, anytime you see national origin in a civil rights statute, language discrimination has clearly been found to be national origin discrimination. Okay, so again, we go back to ESSA, which is the latest in the long chain of ESEA, No Child Left Behind, federal funds to improve and enhance language acquisition program, and also including accountability measures for students who are English learners. That's both under Title III originally, and now under Title I. So it's not just whether or not services are being provided, it's accountability measures. In other words, what are the results? Are you getting results? I believe we've hit our first question phase. Any brave people with legal beagle questions?
Well, and so thank you so much, Sarah. Robin has kindly agreed to moderate the questions for us. So Robin, are there any questions in the chat that would relate to what Sarah has shared with us so far?
We have no comments in the chat.
All right, well, that makes it nice.
Wow.
Sarah, you've covered things so thoroughly that everyone is satisfied with the information you've shared. So thank you so very much for that overview. And thank you for teeing me up, essentially, because what you have shared as this historical context helps explain why we have the current civil rights in place that we have for students who are English learners. So again, thank you so very much for that overview, Sarah. And I will note the second portion of the presentation, as I said, will discuss some of the legal rights of students who are English learners. There are inevitably things that we will not have time to discuss today or that don't come up in our conversation. This is not comprehensive to cover all of the possible legal rights that a student may have, but it is an overview of the most essential legal rights that a school or an educator should be aware of. And to let you know, there are resources provided throughout the training. So there are many links provided, and at the end of the training, there are a few more links provided for you. And one of those links is to a very important guidance document from the US Department of Justice and US Department of Education, which is referred to as the Dear Colleague letter. So the rights that I'm going to be describing for you now stem from that Dear Colleague letter, which you can find linked at the end of this presentation. So the first right is the right to be identified. What we mean by that is any student who could benefit and has the legal entitlement to language acquisition support services has the right to be identified as such. And that right is described in Title I of the Every Student Succeeds Act. And in that section of the Every Student Succeeds Act, it says, when a student enrolls in school at the beginning of the school year, a district has the responsibility to ensure that that student is appropriately identified as a student who is an English learner within 30 days from the start of the school year. And the parent or guardian must also be notified within that time frame. If a student enrolls after the start of the school year, then that 30-day window remains in effect, but the notification to parents must be sent within 2 weeks of that student's identification. So I will key any ESOL educators who are on the line with us today into this as a change in the guidance that the state of Maine has provided to you. The US Department of Education recently did share with states that some states had misinterpreted or misunderstood the language of ESSA, so that we had actually advised districts to ensure that students who enrolled mid-year were identified within 2 weeks. We now understand that actually they have 30 days to be identified, and the 2 weeks refers to the requirement to notify parents of their identification. So you can expect for updated guidance from the Maine DOE around this, but this is the first time that I'm sharing this information with you. Another very important thing under ESSA is that it required states to implement uniform identification procedures. So in past years across the state of Maine, different districts were using different methodologies to identify students as English learners, including different language use surveys, different screening tools. Under ESSA, it is required that all students are identified in the same way. So that is why we developed one statewide uniform language use survey that all students must be screened with. And I'll talk about that more in just a second. Another important note here is that because it is a student's right to be identified, a parent guardian need not consent to the identification process. And that's because that parent or guardian cannot waive the student's right to be identified. So clearly that can be a little bit of an uncomfortable situation. If you have a parent who wishes for their child not to be administered a screening assessment, that's a difficult conversation for a district to have with the parent. And I'm very happy to help navigate conversations like that if you need any support. So please do feel free to reach out to me. But you do not need parental consent in order to administer that screener. So with each right that I'll be discussing today, I will also be sharing with you some recommendations to help you ensure that you're fulfilling that right. So the first link that I provided here is to a brief training video that describes the language use survey and how it should be implemented. So if you haven't yet seen that video, please do take a look at it. And if you are an administrator who oversees that identification process, you may recommend to your front office staff or anyone who is on the front lines as families come in to register that they view that video. Particularly for low incidence districts who may not have a great number of students enrolling who may qualify for EL status, it's a good idea to designate a specific person to oversee the process. That way you make sure that nothing slips through the cracks. And that link there to the identification process describes in detail how everything should be. And then another good step to take if you perhaps have never needed to screen an English learner or you very rarely need to screen a student, then you want to make sure that you have someone already on staff who is able to administer those screening assessments. And the trainings for those screening assessments are available in the WIDA Secure portal. If you are not sure what that is, you've never heard of that before, please do feel free to reach out to me. My contact information will be shared at the end of this presentation, and I'm happy to help you walk through that process. Okay, second, and obviously very important right that students have, which many of the cases that Sarah described relate to, is a student's right to a language assistance program. So as Lau determined, a student who is learning English cannot simply be provided with the same program that all other students are receiving and call it good, because that student has very specific needs that will, that when met, will enable that student to participate in their education in a meaningful way. So all students who are English learners from grade pre-K through 12 are entitled to receive Esol, or English for Speakers of Other Languages, services until they exit. And that exit occurs when they demonstrate proficiency on our English language proficiency assessment. And in the state of Maine, we use an assessment called Access for ELLs, or alternate access. So what do those services actually need to look like? First, they must be tailored to the individual needs of each student. So the educators involved in that student's programming and designing that program need to have a good understanding of where the student is in terms of their language proficiency, in terms of their content knowledge, and then design a program that will help that student to reach their specific goals. Just as Sarah described from the Castañeda versus Pickard case, a student's program must be based on sound educational theory. And as you indicated, that means that it has to be something that experts in the field generally agree is an effective way of meeting a student's language learning needs. And finally, it needs to be a program that has a good chance, or is reasonably calculated, to help a student reach English proficiency and the ability to participate in the general instructional program within a reasonable amount of time. What is that reasonable amount of time? Well, in the state of Maine, we define a long-term English learner as someone who has been identified as an English learner for more than 5 years. And that relates to the linguistic research that we have access to that tells us on average, roughly, a typical student might need between 4 to 7 years to become proficient in English. Last year, the Maine Department of Education provided districts with some service provision guidelines. And this was a very important step, I believe, because this was our first time to really outline for schools what the expectations are in terms of amount of time and other factors of a student's educational program. One of the big changes or big announcements in that service provision guidance was a note about the consultation model. So what is the consultation model? I think it is defined differently by different districts, but generally when districts refer to the consultation model, what they mean is that a student who is an English learner is fully mainstreamed. That student is in general education classes for the entire educational day and does not receive direct supports from the Esol endorsed teacher, but perhaps that Esol endorsed teacher consults with the general education or mainstream or classroom teachers and maybe provides them with strategies, checks on the progress of the student and things like that. But the Esol teacher, him or herself, does not actually support that student directly. So in our service provision guidelines, we noted that that model is not considered to be based on sound educational theory. And that is essentially because the US Department of Education and the US Department of Justice have clarified through various settlement agreements that there is no linguistic research or theory under which this is proven or this is justified as a model, because we have no evidence that it would be effective. So that's a very important piece of information for districts to have, because we know that in some districts across the state of Maine, services are focused on those students in levels 1 and 2 who have the greatest need. And that's of course understandable due to resources. However, we know that all students through level 4.5, which is our exit threshold, do have this legal entitlement to receive direct supports from the Esol teacher. So resources cannot be the reason that a student who is a level 4, for example, does not receive direct support. Second thing that service provision guidance described was specific service timings that a student should receive. And I say should because this is not in legislation for the state of Maine. This is not in any federal legislation. This is a recommendation. And the recommendation, again, is based on all of the settlement agreements that the US Department of Justice has posted to its website. And those are public and available for anyone to read if you would like to see them. But essentially, when the US Department of Justice investigated any district who had a complaint or an investigation related to the amount of service that was being provided to students who are English learners, uniformly, the US Department of Justice determined that all students who are English learners needed to receive a minimum of 1 period per day of ESL or Esol instruction. So we based our service provision guidance on that information, as well as direct conversation with the Office for Civil Rights, in which they clarified for us that yes, indeed, all students who are English learners should receive at least 1 period per day. And in many of the settlement agreements, they specified that a student who is in level 1 or 2 should actually receive 2 periods per day. So I recognize this as, for many districts, much more than what is currently being provided. And I'm happy to support you and thought partner with you in your transition to increasing the amount of service that you provide if you find yourself in that situation. Okay. So a few recommendations to help you ensure that you are meeting this right of students who are English learners. First, every district or every SAU should have a LAU plan. An LAU plan is essentially that document that describes how the district ensures that it meets all of the rights of students who are English learners. So one of the things that I advise you to include in your LAU plan is provisions for holding an annual meeting the Language Acquisition Committee for each student who is an English learner. And I have linked here to a presentation that Robin Fleck, our ESOL consultant, led, which describes the process of a Language Acquisition Committee meeting. And it also describes the student's individual language acquisition plan and the elements that you may consider including in that language acquisition plan. So your LAU plan should describe that process and how it looks in your district. Another very important thing to ensure is that parents and guardians are meaningfully included in the development of a student's program. And that's because we know that parents and guardians provide an enormous wealth of information about what works well for their child, about what their child needs. They also provide to us cultural and personal and linguistic details that can be very helpful in designing a student's program. And of course, we want the student's program to be something that parents feel comfortable with, satisfied with, and that works for them and for their child. I also recommend that you keep records of these service plans and that they are kept in the student's cumulative file. Okay, third right is the right to sufficient resources and staff. So this also connects to what Sarah shared with us earlier, that a program has to be adequately funded and have adequate staffing in order to be effectively implemented. So sufficient resources means that they have facilities that are comparable to any other student. Unfortunately, over the course of our country's history, there have been cases where students who are English learners, their classes take place in a basement classroom or in a small supply area or something to that effect. And US DOJ and the Office for Civil Rights have been clear that is not an acceptable practice, and that students who are English learners need to have facilities that are on par with other students. And the same, of course, applies to instructional materials. Excuse me. And then staffing. And I think this is perhaps the bigger challenge for SAUs across Maine, to ensure that you have sufficient staffing to make your ESOL program effective. Staffing has to be responsive to the needs of the students that you have. So unlike special education, where there may be specific caseloads that are regulated in legislation, there is not such a specific caseload regulation for ESOL. That's partially due to the fact that students who are English learners are so diverse. It is not a monolithic group where we could say for every 10 students, you must have one teacher, for example. There just is not that level of heterogeneity. So what is necessary is that depending on the needs of those students, for example, if you have 10 newcomers, you may have the same need for staffing as if you had 20 more advanced students. So it has to be just based on what the students need. And this is the third bullet on this page, I think, is one that I know I would like to devote more attention to, which is making sure that administrators are well equipped to evaluate the effectiveness of an ESOL teacher and of an ESOL program overall. I think in many districts across the state of Maine, it is the ESOL teacher who holds the greatest awareness and understanding of ESOL, obviously, but it is really important for administrators to also have at least a general awareness of what best practices are in ESOL, so that when they go and observe a teacher or when they assist in the evaluation of a program, that they have a good understanding of what to be looking for. And there are plenty of resources out there that can help you, and I'll describe those in just a moment. So in that same service provision guidance, we also clarified, and this is directly from the Dear Colleague letter that I referenced a moment ago, that edtechs, tutors, or other educators cannot provide the core ESOL services that are required by civil rights law, even under the supervision of an ESOL endorsed teacher. And I will put a small condition here, which the US Department of Education did clarify, which is that only as an interim emergency measure where staffing could not be secured, and I mean ESOL qualified staffing, then it could be considered acceptable for a district to use an edtech, tutor, or other educator to provide those ESOL services. But a district would need to demonstrate that it had made every feasible attempt to secure appropriate ESOL qualified staffing. So if you find yourself in a situation where you are a district administrator or school administrator who is struggling to find ESOL staffing, please do always feel free to reach out to me. I maintain a list of consultant teachers who are willing to work on a part-time basis as a contracted employee to support you. So if you need staffing, please don't feel like you're alone. I'm happy to help however I can. I'm also happy to help by sharing job advertisements with the field if that would be something that you'd like me to do. So please do feel free to reach out. Okay, a few recommendations related to these rights. From one year to the next, you may not be able to anticipate the number of students who are English learners that you will have in your SAU. So it is wise to try to build in some flexibility into your school's budgets so that should you have some fluctuations that you are prepared financially to secure appropriate staffing. In those smaller, low incidence rural districts, as I said, you can certainly consider reaching out to me and I can help you perhaps locate a consultant who could support your needs. And that consultant could provide face-to-face services or remote supports, whether in COVID times or other times. Sometimes remote supports may be a solution that helps to get services in an area where they are not otherwise available. You could also consider making use of your regional service centers. So multiple districts could pool together to hire one ESOL teacher that would meet the needs of the students in that region. And then my final recommendation, if you are struggling with staffing, is to consider finding someone who is already in your district, who is already on staff in some other capacity, who may have some flexibility in their scheduling, and encourage that person to become ESOL endorsed. That I think is probably one of the best steps that a district could take, because then you have someone who is part of the school community already, who lives and works there already, and would be willing and available to meet the needs of students who are English learners should they appear. And two types of educators that I often advise districts to consider are world languages teachers, if you have one, and special educators, because they are familiar with cultural responsiveness, differentiation, and other strategies that can be very effective in meeting the needs of students who are English learners. Okay, so if you are an administrator who needs to evaluate or oversee a teacher of ESOL, then here are a couple of resources that you might consider taking a look at. First, WIDA, which is the company or the organization that provides us with access for ELLs and alternate access. They also provide a great wealth of professional learning resources. So this link that I provided for you here will describe some of the e-learning offerings that they provide. And those are available to any educator in the state of Maine. You just need to have a WIDA secure portal account. If you don't have one and would like some help getting one, please do feel free to reach out to me. So that's a great place to start, just to get a foundational understanding of ESOL if you're an administrator, or if you're an educator who is not an ESOL educator. Those are some really great courses for you to start with, just to build up your understanding. If you are responsible for observing and providing feedback to ESOL teachers, then you might consider using this SIOP checklist that I have linked to here, which again just describes some of the best practices in teaching English to speakers of other languages. And here I will pause for any questions. Robin, do we have any questions in the chat?
We do. We have, are there any changes to ESOL endorsement requirements to address teacher shortage?
So it's in normal times, generally the requirements to become ESOL endorsed are fairly minimal. If you are already a certified teacher, you can become conditionally endorsed with 3 courses and then fully endorsed with 5 courses. So it's a fairly minimal requirement compared to some of our other certifications. But in the current conditions under COVID, there is an emergency waiver in place. So I cannot claim to be a certification expert by any means, but if you would like to find out more about that emergency waiver please do reach out to our certification office at the Maine Department of Education, and they will give you all the information you need around that. But it is, in light of the current situation, even easier than normal to become ESOL endorsed.
Is there an age where these student rights stop? And this person, Megan, was thinking about adult education.
So if an adult education program is a recipient of federal funds, then they would be subject to Title VI of the Civil Rights Act. Do adult education programs typically receive federal funds? Yes, they do, Sarah said.
Yes, they do, but I don't know if they're the same federal funds.
Okay, well, so the Title VI of the Civil Rights Act simply states that any organization that receives federal funds would be beholden to that law, which means that they would not be able to discriminate against a student on the basis of national origin, which Sarah told us includes language. So the rights that a student has in adult education are likely very similar to what I'm describing here. But the rights that I'm describing here are generally geared towards pre-K-12. So Megan, since you're with us, I don't know if you want to speak to this question a little bit.
Well, so I asked the question, actually. I mean, I was specifically thinking about, for example, one of the things that you mentioned, like that a tutor can't provide ESOL services to a student, even under, you know, supervision of an ESOL endorsed teacher. A lot of adult ed programs are using tutors with their English language learners. So now I'm wondering whether they should be doing that.
So I would butt in here to say not definitively yes or no, but to suggest that, like April said, to the extent the genesis of this is Title VI, then clearly adult ed is part of it because they're a federal funds receiver. To the extent that the genesis is allow as codified for K-12 students, some of the specifics may not be equally applicable. But again, you need to look holistically as to whether or not what you're doing could be deemed to be unequal or inequitable treatment based on an individual's language needs.
Thank you, Sarah. And so to go one step further, I would say for adult education programs, it does come down to what is equitable treatment. So if you are providing supports and services to other students who are not students who are English learners through tutors or other educators who are not certified teachers, then that may make it a somewhat more acceptable choice to also provide such services to a student who is an English learner.
Great, thanks, that's helpful.
Yeah, that's all sort of a way to say that while the principles don't change, the specific technical guidance can be more directed.
Thanks.
Thank you.
Do you have time for another one, April?
I think we could do one more. We are approaching here 4 o'clock, so I will move through a little bit quickly because we still have about 20 slides remaining. So I think one more question and then we'll move on.
What happens when students or parents do not want to participate in the WIDA access testing due to test anxiety, learning disability, etc.?
Thank you. So I think we will address this in a moment, but just briefly, the position of the Maine Department of Education has always been that all students will participate in all required federal or state assessments. So the Maine Department of Education does not have an opt-out policy, meaning that we don't collect information from districts about students whose parent or guardian wishes to opt them out of an assessment. I know that districts, of course, do have their own policies related to this, but for the purposes of the Department of Education, if a student doesn't participate in a required assessment, such as Access for ELS or alternate access, then that student is considered a non-participant, and that can have implications on the state accountability model, which we refer to as Maine's model of school support. The implications for the student, him or herself, are that student may not be able to exit English learner status because the only means by which a student can exit is to demonstrate proficiency. And the only way that we recognize proficiency to have been demonstrated is through that ELP assessment. And of course, we then would not have the information that that assessment provides to us about a student's proficiency level, about how they're progressing in each of the 4 domains. So those would be the major implications of not being administered access for ELLs or alternate access. And again, as I said in the beginning, but I know some people have joined us, if there are questions that we are not able to respond to live today, we will be transcribing them and providing written responses, which I will happily send out to all of the people who registered for today's training. So please do feel free to put your questions in the chat, and if we don't get them to them today, you will receive a response from us. Okay, on to our next right. And I will move a little bit quickly just because we are now in the home stretch. So the next right is to meaningful access to all curricular and extracurricular programs. So I've provided a list here of some of the typical programs that we would consider that an English learner should have access to. And those range from pre-K programs through career and technical education, advanced placement, gifted and talented, all extracurricular clubs, sports, etc. Extended day and summer programs. So all of those would apply. So here are some recommendations to ensure that this right is met. First, as you share information with parents about the various opportunities, parents and guardians, about the various opportunities that are there for students, you want to make sure that you're sharing that information with all parents in a way that they can understand. So for some parents, that may mean that they not only need translated or interpreted information, but they also need that information to be geared to them in a way that they can grasp culturally, because we have students and families coming from a wide variety of backgrounds, as we said. So you may need to explain and describe things in a different way for some parents, because, for example, let's take a common high school event, which is prom. Prom is a concept that if you're not from the United States, if this is not where you went to school as a student yourself, then you wouldn't be familiar with that concept likely. And so it may need to be explained to you. Or really many of the events and activities that schools host are special to the United States. So just to keep that in mind as you communicate with parents and guardians. As we ensure that students have access to all of these different programs, we need to also ensure that there are supports in place so that they can succeed in them. So an example comes to mind of career and technical education. So if a student wishes to participate in career and technical education, that should be something that is made available to them. And once they are there in that program, there need to be supports in place, such as making sure that the CTE teachers are equipped with strategies to meet the needs of a language learner in that program. The same would go for an AP class. If a student is an English language learner, but is amazing in calculus, then they need to be enabled to participate in an AP calculus course with supports that will help them to succeed, because otherwise it would be their language proficiency only, barring them from meaningful participation in that class, and that would be an issue. Having options that enable students to participate in programs, extracurricular or curricular, that make sure that they're not excluded on the basis of religion. That's a very important one. So I was happy to see in the news, I think a couple of years ago, I believe it was during high school, was in the news because of providing sports hijabs. And that is a very, very simple step that can be taken, but it goes so far in ensuring inclusivity so that students can participate, because ultimately we want all students who would like to participate to be able to participate. And you may also find some students, depending on their cultural or religious background, they may be comfortable or more comfortable in single gendered groups. So that might be something that a district would consider doing. Also, CTE, I think, provides a good example of these making participation decisions on a case-by-case basis, because some districts, it's come to my attention that some districts have policies that prohibit any student who is an English learner below a certain level, for example, level 3, from participating in CTE. And we know from the US Department of Education that those kinds of blanket policies are not considered acceptable because they are in effect discrimination on the basis of language. So it needs to be a case-by-case decision that is in the best interest of the student. If a student who's a level 2 wants to participate in a nursing program, then the CTE program and the SAU would need to make a decision together about whether that's appropriate for the student and why it wouldn't be if the decision is no. And then finally, providing transportation can be a very helpful way to help to enable students to participate in after-school programs, for example. Okay. So next right is the right to integration with peers. In the Dear Colleague letter, they specify very clearly that separation of students who are English learners from their peers who are not English learners should be done only when absolutely necessary and for educational benefit. And the reason that they were explicit in putting this here is that there is a history of segregation in some schools across the country, whether it's on the basis of race, language, national origin, etc. So when we say for their educational benefit, we're talking about, for example, newcomer programs. When a student is newly arrived to the United States, for example, may not have had previous exposure to English, there may be a legitimate educational purpose to grouping such students together and providing them with intensive English language development services in a single classroom. So US Department of Education has specified or clarified that that would be an acceptable practice only for the part of the day that that's absolutely necessary, and that for all other parts of their instructional day, they should be integrated with their peers. And that such a program generally should be limited to a period of a year. And if it goes beyond that year, then that could be viewed as undue isolation from their peers. So as the second bullet indicates, for all parts of the day that are not language dependent, where there is not an educational benefit to having students grouped together due to language proficiency, such as physical education, art, music, lunch, recess, and assemblies, then students should be integrated fully for those parts of the day. Okay, so a couple of recommendations. As you design a student's schedule, of course, you want to keep this right in mind and make sure that their schedule does build in times for integration throughout the day. And to make integration successful, it's so essential that there is common planning time for teachers. And I know that's something that many districts across Maine are working towards now. It hasn't always been intentionally built in, but ESOL teachers really need to be able to coordinate with the other teachers that are serving that student so that the ESOL services can be effectively tailored to support the student while they're in the mainstream, and so that while the student is in the mainstream, their core content teachers or their classroom teachers are well equipped to meet their needs during that portion of their day. So that common planning time is really of utmost importance. And then finally, making sure that not only teachers, but all staff, all members of the school community understand how to interact with students in a culturally responsive and welcoming way. So whether the student is in the library or the lunchroom or wherever they may be, that those portions of their day where they're integrated with their peers, that they feel comfortable and safe and welcomed. Okay, moving quickly. Number 6 is the right to appropriate special education identification and services. And this one is, they're all so important. Each time I turn to a new slide, I feel like, oh, this one is really important. But this one really is so important. So in the beginning of today's presentation, I mentioned the English Learner Data Dashboard. And one of the points that that data dashboard shows is the rate of identification for special education, both for students who are English learners and for students who are not English learners. And you'll see that in the state of Maine, they're actually very equal. I believe it's 17.4% versus 17.9% or something to that effect. So that would suggest that perhaps we are not over or under identifying students who are English learners for special education to a great extent in the state of Maine. If you look at some other states, you'll see that those numbers are much less coordinated. So I think that's a positive that we can celebrate but I also think that there's always room for improvement. So one of the things that we want to make sure happens is that if a student who is an English learner is showing signs of a potential disability, that there is not a delay in ensuring that they are evaluated for special education or disability related services. So there is this persistent idea, and I'm not sure where it came from, but many educators have come to me and said, well, I have a student who I think may potentially have a disability or a special education need, but this student hasn't been here for 3 years, so I can't evaluate him yet. I don't know where that 3-year concept stems from, but there is no such thing in federal or state law. So once it has become clear to an educator that there is a potential disability or potential need for special education services, then there really should not be a delay because of a student's language proficiency. That said, it is so important to ensure that before the referral happens, that a district or a school makes sure that the education that a student has been provided with isn't the reason for a student's lack of progress. So what I mean by that is ensuring that that Tier 1 core educational program is really strong and that the student's language learning needs are being met through that Tier 1 programming. And of course, Esol services are part of Tier 1 core educational services. And then if a student does reach the point of needing to be evaluated, that in that evaluation process, the student's level of English language proficiency is taken into account. And if at all possible, those evaluations should be conducted in the language that the student is most comfortable with, because that language is most likely to yield an accurate result. Of course, there are not, at this point in time, a wealth of assessments out there that we could pull from in multiple languages. So what some districts are opting to do is to administer those evaluations through an interpreter. So for example, you have an evaluation that was designed in English. The student's primary language is Chinese. So the teacher who is responsible for the evaluation works with an interpreter in Chinese who delivers the information to the student in Chinese. The student responds in Chinese and the interpreter relays the information to the teacher in English. Is that a perfect solution? Certainly not. However, it can be a way to get a piece of the puzzle and some information that will help the IEP team to make a determination about that student. And finally, of course, this should go without saying, but English language proficiency cannot be the basis for a special education determination. So there has to be something else involved beyond just typical language development processes. Sarah, did you want to share anything on this slide? I noticed that you're unmuted.
Oh, perhaps I'm unmuted because I never remuted myself after I commented about something else.
Okay.
Although I would agree that this is a particularly significant topic because either misidentification or failure to dual identify has certainly been raising its head more recently. I haven't seen this number of special education related situations that are cross-pollinated with language. It's on the uptick.
Okay, well, thank you for that information. And this is something that Robin, who I mentioned is the Esol consultant here at the department, she and I have been working on. We are in the process of devising a guidance manual for districts to help them make those identifications of students who are English learners and or students with disabilities. So that is forthcoming. I wish I could give you a specific date that it will be available to you, but just know that it is in the works and we hope to have it out available to districts to implement very soon. Meanwhile, here are a few recommendations that may help. In conversations with parents and guardians, listen to what they are saying about the student's behavior, cognitive abilities, and language development in their primary or home language. So for example, if a parent shares with a school, I'm having a really hard time understanding my child when he speaks in Arabic, that is potentially significant of a speech language need. So hearing that and taking it into account. Knowing some of the linguistic differences between English and whatever other language a student may speak can also help to help educators know whether there is a potential speech or language need manifesting. One of the features of languages that it's helpful to know is that there may be a language that the script actually goes from right to left. And so just awareness of something like that can help prevent over-identification for things such as dyslexia, for example. And Arabic is the second most commonly spoken language after English. So it's English and then Somali and then Arabic in the state of Maine. So we do have a lot of students in the state of Maine who speak Arabic, and this could certainly be something that affects them. And finally, and very importantly, in the state of Maine, many of the students who come here learning English are coming from some pretty difficult backgrounds. So we do have students coming to us who have experienced enormous trauma or who have had limited or interrupted education. And so sometimes trauma or limited or interrupted education can look like a special education need, when in fact it is just adjusting to new circumstances, dealing with trauma, or orienting oneself to school. Okay, right to ESOL program options. So this is another question that comes to me very frequently, and it is something that is somewhat different from the special education world. So I'll point this out, that a parent or guardian does have the right to opt their child out of ESOL services or a particular type of ESOL services, but that right is somewhat constrained. And that's because the student himself or herself also has a right to receive the services. So if opting the student out of services would prevent the student from progressing in their English language development or academically, then even if a parent or guardian opts the student out, the school still has an obligation to ensure that that student's needs are met. So that can be another somewhat uncomfortable conversation with a parent to say, well, we understand that you have chosen to opt out, but we must still do something for your child. What that something looks like is flexible. So it doesn't necessarily have to be the same ESOL program that is provided to all other students who are English learners, but it does need to be something in place to ensure that the student is able to progress. And I'm going to skip over the other things on this slide that you can certainly read on your own time if you would like, just because we are approaching the end of our time together. So if you have parents or guardians who are wishing to opt out, sometimes it can be due to some conceptions of what ESOL programming means or what English learner status means that may be based on inaccurate understandings. So having a conversation with that parent or guardian to let them know this is what the ESOL program looks like, this is how it will or will not affect your child's academic programming and their progress and their opportunities. And maybe sharing a sample schedule or letting them know what their student's instructional day may look like can help to ease any concerns that they may have. Because they may, for example, believe that if their student is identified as an English learner, that they will be unduly separated from their peers, or that they won't be able to enroll in AP or things like that. In any conversation with parents and guardians, we want to make sure that we are really being positive about multilingualism and multiculturalism, that we are celebrating home and primary languages as a wonderful asset that they are, and that we explain English learner status as a positive thing, which enables a student to receive supports to help ensure that they succeed. And of course, as I talked about before, in the ILAP development process, making sure that parents and guardians are included there so that they are part of that decision-making process, and that it is not a program that is just being handed to them, but that they themselves have helped to design that program. Okay. Right to exiting and monitoring. So as I mentioned before, a student who achieves English language proficiency, which we here in the state of Maine define as an overall composite proficiency level of 4.5 on Access for ELLs or level P2 on alternate access, that demonstration of proficiency automatically exits a student from English learner status. So it is not a decision that a team of educators or a single educator makes, rather it is based on that score. And just to let you know, a couple of years ago, or actually now almost 4 years ago, the state of Maine did do a review of its identification and exit policies and considered a variety of exit policies. And we received guidance from the U.S. Department of Education that additional criteria could be considered above and beyond the ELP assessment score, but not as a substitute for that assessment score. So many educators feel that it would be better to have some teacher input or maybe other assessment scores involved in exit decisions. But U.S. Department of Education has clarified for us that you must have a proficient score on a valid and reliable English language proficiency assessment in order to leave English learner status. If we were to add in other criteria, then they would have to go above and beyond that ELP score. When a student does exit English learner status, then it's important to make sure that that student continues to be monitored to make sure that they are able to progress academically and continue to improve their English. If an educator sees that a student who has exited English learner status may actually have become not proficient again over the course of years, then it is always possible to rescreen and re-enter a student into English learner status if necessary. There is a common idea out there that monitoring is a 2-year period. And based on the federal guidance, they do recommend intensive monitoring for the first 2 years after exiting, but there is no definitive end to the monitoring process. Any student who's a former English learner, there should be a means by which educators are keeping track to make sure that at any point during that student's academic career, if their English language proficiency were to dip or drop, that they could be considered for English learner status again. So monitoring is not a 2-year period, it's indefinite. The first 2 years should be the most intensive. And I have provided here a quick resource, which is the US Department of Education English Learner Toolkit. And that, I think, is probably the best place to turn for information about monitoring. So if you haven't checked that out, please do take a look. If you're an administrator, you want to make sure that in designing an English for speakers of other languages educators teacher schedule, that you want to make sure that there is time built into his or her day to do that monitoring, because it is something that takes time. And as students exit English learner status and spend their day in the general education classroom, it's important to ensure that those teachers who are with the student for their day know what signs to look for that a student may need to be rescreened, so they can refer that student to the Esol educator. Okay, I'm going to fly through because we only have 7 minutes remaining. So write to an Esol program that is evaluated. As we talked about in the beginning with the court cases and legal history, not only must a district provide a program, but it must be a program that is effective. And how do you make sure that it's effective? You do that by regular evaluation. So there are some points suggested here to evaluate your program. And that same EL toolkit that I mentioned for monitoring, they also have a wonderful chapter about program evaluation. So I highly recommend taking a look at that. The Office for Civil Rights also has a program evaluation tool available, which kind of provides a checklist for you so that you can measure how your program is doing. And then, of course, SAUs generally have some kind of annual strategic planning process, comprehensive needs assessment process. So it's advised to make that Esol program evaluation an integral part of that annual needs assessment or strategic planning process. And of course, involving your Esol educators in that evaluation. Okay, meaningful communication. So this is something that I very often receive questions about. Do I need to translate this? Do I need to interpret this for families? And the fact sheet that I have referenced here is the information that I typically share with schools, which says, and this is again from US DOE and Department of Justice, it says that schools must communicate information to parents in a language they can understand about any program, service, or activity that is called to the attention of parents who are proficient in English. And they provide a list of some of the core documents that would be expected to be translated. One thing that's clear though is if you're in a district with many different languages spoken, that it may be something beyond what is practicable to translate every document that goes home to families in multiple languages. That would be an enormous expense, which may not be feasible for a district. So here are a few recommendations that may help. Develop a language access plan for the SAU, and that link takes you to a wonderful resource from Usdoe, which describes what a language access plan is. And that's where the district would indicate which items will be translated and in which languages, so that you establish that as a policy. For anything that you are not going to provide in translation, I recommend including a notice on that document that says, if you would like interpretation of the information in this notice, please contact. And of course, that would need to be provided in the language that the family can understand. I'm going to glance over some of these. In your office, as families come in to see the school, it's really important to make sure that there's signage available so that they can be made aware of their right to interpretation and translation and how to access it. So again, there's a note about making sure that there's a notice included, letting families know that interpretation is available. A very important one is that automated interpretation and translation tools, while they have come very far, they are still not a substitute for a human. So it is still necessary to make sure that you get translation and interpretation services from a qualified professional. There is not a professional licensure for interpreters and translators at this time in the state of Maine. So what we mean when we say qualified is that they have had some formal training in interpretation and translation and the ethics thereof, but not that they are simply a person who is bilingual, and certainly not that they are, you would not want to rely on a minor or someone who has a family member and happens to be present. And we have 3 minutes for probably the part that many of you have been waiting for, which is what we do for civil rights in the COVID-19 context. The best resource I can point you to for information about that is this Usdoe fact sheet, which was released in May. And basically what it clarifies for us is that no civil rights have been waived in light of the COVID situation. Civil rights are still in full effect. So Usdoe is not offering flexibility in whether students will receive ESOL supports. They are willing to offer flexibility in how those services are provided. So they recommend continuity in providing those services to the greatest extent possible. And they remind districts that not only must students receive ESOL services, but for the courses that they participate in without the ESOL teacher, that those courses also be accessible to them. So how do we do that in practical terms? When you're creating schedules for students, whether they are remote, hybrid, or fully in person, that ESOL services are prioritized, that they're not an afterthought that you then work into the schedule somehow, but they are an essential part of the schedule as you develop it. As I talked about before, building in that collaboration and planning time, it's always been important, but it is absolutely critical in the time of COVID because students are spending a lot of time on their computers with educators who may not have had ESOL training. So the ESOL educator is working very hard behind the scenes to make sure that those core content or general education classes are accessible. So that time needs to be built into their day to be able to do that. You can provide ESOL services in a variety of ways in the COVID context or in general times. Co-teaching, I think, is a really exciting and effective way to meet the needs of an English learner. So for example, you may have an English language arts teacher who is paired with an ESOL teacher, and they work together to make sure that the needs of that English learner are met in the ELA period. You may also consider providing ESOL services over phone or video calls. Usdoe did clarify that instructional packets could be an acceptable means of supporting a student in light of the COVID situation, especially for young students who may not be able to access technology as easily. And project-based or experiential learning could be a means of supporting an English learner in a remote context when other types of assignments may not be as valuable for them. Okay. So there's so much that can be done to help remote learning work for English learners. We recommend a few specific things here so that every lesson or every class that a student participates in has a clear content objective that is paired with a language objective. So the language objective is essentially what language skills the student needs in order to be able to participate in that content. And if that's something that you're not familiar with, the Esol educator in your district will be able to explain it to you better than I can in this brief amount of time. You may consider providing extended time for assignments. If you are showing students videos in the remote setting, providing closed captioning or subtitles can help make them more comprehensible to them. Providing reading materials at various levels on the same content. Providing translated materials if possible. If you have written materials that they're accessing online, that there be a text-to-speech feature built in so that they can hear the text on the page. Offering online bilingual dictionaries as a resource. Building in word banks and sentence frames as part of the content instruction, and deliberate peer groupings are some ways that, that remote content instruction can be made more accessible to a student who's an English learner. As I promised in the beginning, here are a few resources that you may turn to for more information about the rights of a student who is an English learner. So those first few things are really about those legal rights. The Allow Plan template is a useful tool to help you make sure that you're covering all of your bases if you're an administrator. WIDA, as I said before, offers many, many professional learning resources. And another website that is very well known in the field of ESOL is Colorín Colorado, and that has lots of articles, instructional resources, and just tons of information, whether you're an administrator or teacher, that is enormously valuable. And we have come to our final question period. And I know that was a lot of information, so I'm sure that there are some questions. Robin, would you share maybe 2 questions with me?
Well, we've got one from Caitlin. Regarding the scheduling and periods per day, is that based on a 4-period schedule with alternating days, or is there a percentage of time to use as guidance for scheduling?
Thank you for that question. Yes, so you have the presentation slides. If you click on the link that says Service Provision Guidelines, it defines for you in a bit more detail what is meant by period. But essentially, the idea is if a student is receiving 45 minutes, for example, of ELA instruction or math instruction, that would constitute a period. So if a student should receive 1 period of ESOL, then it should be basically equivalent to what they would receive for those core content areas. In the context of COVID, I would evaluate it by a similar method. So if a student is receiving 30 minutes or whatever it may be of ELA instruction every other day, then you may seek to have comparable or roughly equivalent time for their ESOL services.
And Jonathan says, our ELs attend all mainstream content classes. Therefore, there is no time available for EL support unless students are removed from UA classes, Unified Arts. How do we avoid discrimination if we pull them out of UA classes?
Wonderful question. And this is a very big challenge for everyone. Designing a student schedule in a way that ensures that they are integrated with their peers to the greatest extent possible, that they are not removed from their core content areas to the extent possible, and that they are able to participate in everything that other students are able to participate in is a very big challenge. And actually, Robin, who I'm extremely grateful for, and I have been collaborating to create some sample student schedules, which would provide an example of what scheduling may look like using scheduling best practices. Something that may be considered, I know this is not necessarily feasible for every district depending on your numbers, But co-teaching, as I said before, is a wonderful way to keep a student in the mainstream and also ensure that they're getting those ESOL supports. If there are times in the day where, if there are intervention blocks, for example, those intervention blocks may be leveraged for ESOL support sometimes. Study halls, if possible, can be leveraged for ESOL supports. I think it's perhaps more challenging at the lower grade levels because a student normally would spend their day integrated with their peers 100%. So our sample schedules, I hope to have available for you soon. But in the meantime, Robin, do you have any other thoughts that you want to share about scheduling?
I think you really have to work with your administration or guidance, particularly at the high school level, your administrators, to have them fully understand how essential the services that you are providing and what you are supporting. And many of our teachers in Maine travel to multiple schools, and they, language arts is at the same time in 4, different schools, and they just can't be there. So sometimes you even have to get cooperation between schools and when they will offer programs at various grade levels. So it really takes a lot of collaboration to make it work.
Thank you, Robin. So I'm afraid that we have reached our time limit for today. There is so much more to be said, so many other things that we just have not been able to cover today. But I really, really appreciate all of you taking the time out of your incredibly busy schedules to be here to hear about this very important topic. And as I promised, we will respond to all of the questions that you entered in the chat via email, I hope by the end of this week. And this presentation recording hopefully will be available on YouTube within the next couple of days. But it goes without saying, I hope that I'm here as a resource for you. If you have any questions about today's presentation or about any aspect of providing services to English learners, please do feel free to reach out to me by email or by phone at any time. I'm always happy to speak with educators, so don't hesitate to call me. And I, again, thank you so much, all of you, for your time. And I wish you the very best in serving your students who are English learners and in managing this current situation that we're all coping with. So thank you
very much.
Thank you.